Hi, Dave Bliven, Bronx and Westchester divorce attorney, here with another episode of Lessons from the Divorce Wars. So I had a case many years ago, and this is a lesson where you should never be too sure you have a settlement in place. Here's the case. So parties had a bunch of properties. We took a deposition. And it was a relatively cut and dry case. There wasn't too much to dispute. We got appraisals done on the properties, so we knew what they were worth. We knew what the mortgages were worth. Both parties were looking to split the properties. There wasn't really too much in the way of alimony or anything. But husband's attorney seemed like they wanted to settle the case. I discussed settlement with my client, and we put a settlement on the record at the deposition. And I thought I got a pretty good deal for my client, and I went out. After the parties left, I spoke with opposing counsel, and he said, What do you think about this settlement? I mean, do you think, your client got a good deal? And I said, yeah, I think my client got a pretty good deal, which is true. And he took that to mean that I got one over on him, that my client got a better deal than what she deserved. And so what happened within days or so after the deposition, all of a sudden, the husband fired that attorney, hired a new attorney, and came into court saying, now I want a better deal. And here's the problem. When you put the basic terms of a settlement on the record at a deposition, that's still not a good enough settlement. You have to have a written stipulation of settlement drawn up, executed with the parties. The only other settlement that's accepted by the courts, at least in the greater New York City area, is a settlement on the record before the judge, and you're best advised to have what's called an adoption of oral stipulation done at the time or shortly thereafter and notarized and uploaded into the court's website. If you don't do all that, then anything else that you do to settle your case is not going to be good enough. So, lesson is, make sure when you do a settlement that you do it right. You get the written stipulation of settlement done, or the stipulation in front of the judge done with the adoption of oral stipulation. That is the only time your settlement is absolutely rock solid, of course, assuming the settlement is properly done in the first place. So this is Lessons from the Divorce Wars. If you want more information on divorce cases, check out my blog. You can find that at blivenlaw.net/blog. Thanks a lot. Take care.